everybody. I am so excited. Oh, I'm so excited. Okay. I do not have a lot of time. I'm traveling to LA today. I should be packing and getting ready. I don't want to give too much away about my travel itinerary because, you never know who's watching my videos. But I want to jump right into this. There were some new filings that came out, and they do have to do with Miss Lou Taylor, Robin Greenhill, TriStar Sports and Entertainment. So we're going to go into those right now. Now, the one thing I want to say is this entire live stream will be reading from the documents that Noted Your Honor posted on Twitter. So if y'all are on Twitter, I really strongly suggest that you do go and follow that account. I really love the person. They're really nice and they're always up to date on these filings. So the filings are not actually even available on the docket yet. I'm told that they were actually put into the attorney docket, like the attorney portal. So I'm not sure who or how got these, but now they're on Twitter, so we're going to read them together. So let me just go ahead and share this screen with y'all. Okay. No, this is better. Okay. So I'm going to click on the actual, screen and stuff to make things bigger. But this is just what we're going to be reading from. So Noted Your Honor says, new thread, Robin Greenhill and TriStar motion to quash. So I wanted to let y'all know, if you haven't been keeping up with my videos or, you're not exactly sure what's going on in Brittany's case right now, Matthew Rosengart has gone ahead and requested to depose Robin Greenhill. Now, Robin Greenhill is a TriStar Sports and Entertainment employee, or at least she had been from 2001 to 2021. And Robin was the person who said, oh, Brittany will work on her birthday and stuff like that. So Robin was requested to be deposed. If you don't know what a deposition is, that's just where you have to go and sit down and answer questions for hours and hours for the other side's lawyer. So Matthew Rosengart wanted to ask Robin Greenhill some questions for hours and hours. And basically, Robin's lawyer is saying, no, we don't want to do that. And she should not have to do that. And so I do have my trusty Free Brittany folder right here. I'm right here. And if we need to go into the documents to see if any lies are happening, we can do that as well. So that is what's going on there. Okay, so new thread, Robin Greenhill and TriStar's motion to quash, meaning the motion to make Robin not have to answer questions. There are a flurry of exhibits attached, and this is a thread of some of the exhibits. So I guess we're going to go just through the exhibits. I need to see the motion to quash, but again, this is not up on the docket. So let's just go through these exhibits. Okay. Exhibit A, email from Matthew Rosengart to Edelman. I don't know how to say his name. I'm going to say it as if it is Edelman, but I really don't know how to pronounce his name or her name. So Exhibit A from Matthew Rosengart to Edelman requesting production of documents. So here we have a nice picture of Mr. Rosengart with his pinstripe. Okay, here we go. Exhibit A. I'm so excited. Okay. So from Matthew Rosengart to Scott Edelman, Diana Feinstein is CC'd, and then there's some attachments, Hudson v. Foster, and then up here, look, Britney Spears subpoena TriStar, and then Britney Spears subpoena-ing Robin Greenhill. Now, those subpoenas and the attachments of this email, which this email is just an exhibit that is attached to a court filing that we do not have yet, if that's confusing, sorry. So here's an email. It was sent on October 1st from Matthew Rosengart to Robin Greenhill and Lou Taylor's lawyer. Okay. Scott, please see the attached subpoenas for TriStar and Robin Greenhill, which I am emailing you as a courtesy. We will also serve them personally. Please also feel free to send me all documents regarding TriStar and the 12th accounting separately. Although, as I mentioned, under the Foster case, among other things, our concerns reasonably go beyond just the 12th accounting. Finally, contrary to your suggestion, I do not have a preset narrative. Instead, I have been very circumspect, meaning like I'm looking at the whole picture. Whatever the problems are of TriStar and Robin Greenhill in particular, they obviously are not of my making. Relatedly, I am sure you have read the New York Times detailed expose, and neither has denied seeing, reviewing, or receiving copies of my client's text communications, reports of my client's text communications, or listening to or knowing about illegal, illicit recordings of my client. We will follow the facts and the evidence, seeking the truth as I'm sure you would expect. Oh my God, yeah. We will follow the facts and evidence, seeking the truth as I'm sure you would expect. Okay? I am happy to speak, but in view of your refusal to provide the basic information I requested more than 2 weeks ago, any business, a management agreement, and the total revenues of TriStar obtained from Britney Spears or her estate, it doesn't seem like it would be fruitful at this time for me to speak with you, right? Matthew Rosengart. Okay. So let's go to the next one. That's Exhibit A, an email where Matt is basically just saying, like, I don't really think you're worth my time. Exhibit B, request for production of documents and communications from TriStar Sports and Entertainment related to surveilling Britney Spears. Okay, so this is what Matthew Rosengart asked Robin Greenhill and TriStar Sports and Entertainment and Lou Taylor for. All documents and communications relating to the electronic surveillance, monitoring, cloning, or recording of the activity of Britney Spears' telephone, including but not limited to surveillance, monitoring, cloning, iCloud mirroring, or recording of calls, emails, text messages, internet browser use or history, and social media use or direct messages on social media. Number 2, all documents and communications. Now this would come from TriStar, right? They asked Jamie for a lot of this same exact stuff, but this is them asking TriStar and Robin for this stuff. All documents and communication relating to any recording or listening device placed in the home or bedroom of Britney Jean Spears. All documents and communications regarding the electronic surveillance of Britney Spears, including the decision to eavesdrop, record, or monitor any phone used by her and to place a listening device in her home or bedroom. Number 4, all documents, communications relating to records of all recordings referenced in the request for production numbers 1 through 3, those ones above, including all such documents and records. All communications with Black Box Security or Idan Yemeni concerning eavesdropping on the telephone communications or placing illicit listening device in the home or bedroom of Britney Spears. Then Matthew asked for all documents that reflected, or related to any communication between you, I'm assuming that was the people at TriStar, and any representative of the conservator, including his lawyers. Number 7, all agreements, including any business management agreement purportedly entered into between TriStar and Britney Jean Spears, or between TriStar and James Spears as conservator of the estate. All documents related to any agreements between you and the conservator. All correspondence, whether on paper, electronic, by text, or instant message, relating to any agreement by you to represent the interests of Britney Spears. And you would be TriStar and Robin and Lou. All correspondence relating to your compensation out of the conservatorship estate of Britney Spears. All correspondence relating to any modification of the compensation called for by any agreement between TriStar and Britney Spears. All documents related to payments or approvals for payments made out of the conservatorship estate of Britney Spears for legal representation of Lou Taylor or Robin Greenhill. Okay, so this one's a big one because on the 12th accounting, there is a large hundreds of thousands of dollar line item for, a hundreds of thousands of dollar line item. I think it's like $250,000, $350,000, where Lou Taylor actually tried to use Britney Spears' money to sue an alleged fan for making a website about her. So this alleged fan, Brian Kuchar, it's very public knowledge. Y'all can look this up yourself. It's just like very public knowledge. He had actually ended up settling with Lou Taylor, but she spent and racked up about $200,000 or $300,000 worth of bills. And then she tried to use Britney's money to pay for it in this 12th accounting to sue an alleged fan. What on earth? Anyway, so this particular item here, number 12, is saying, okay, I want all the documents relating to payments or approvals of payments made out of Britney's money to represent Lou or Robin in any lawsuits. So I'm very interested into seeing, why, Matthew is interested in that and whether or not he thinks that was appropriate expenditure of Britney's money. Number 14. Oh, sorry. Number 13. I'm sorry. My nose is so itchy. All documents relating to accounting services rendered by TriStar or on TriStar's behalf related to Brittany, right? So they want to know what accounting services she did. All documents relating to the possibility of establishing a conservatorship over Brittany Jean Spears up through the date of the conservatorship, which was February 2008. So he's saying, I want to know, did y'all have something to do with orchestrating this thing? All documents that refer, reflect, or relate to any communication between the TriStar people and Brittany in any capacity. Oh, sorry, Mr. Spears. God, I'm begging you, Matthew. Please, God, please just start using these people's first names. Every one of them's last name is Spears. You realize that? I love you so much, but please start using their first names. Marion, oh my God, can't wait to see you. Thank you so much. Yeah, I'm so excited. Like, I'm getting on a plane today. Like, I'm going. I might miss my flight because of this reading, but I had to do it, y'all. This is my document. I just needed to read it. Okay. All document. Where are we on? 14. So they're asking Lou Taylor to give them all documents relating to any communications that they had to set up this conservatorship. So it looks to me like Matthew Rosengart is exactly on to Lou Taylor, and exactly that she was involved in the setup of this conservatorship, despite the fact that she has now lied through her lawyers and said that she was not many, many times. The lies are going to catch up to you, Louise. They already have. Okay, number 15. All documents that refer, reflect, or relate to any communication between the TriStar people and Jamie in any capacity other than his capacity as conservator, including without limitation to communications between Lou Taylor and Jamie Spears. Now, this I don't really understand. Other than his capacity as conservator, like what other capacity would he be emailing them in? So I'm not really sure about that. I guess what they're saying, what he is doing this is, like, I already asked you for the stuff relating to the conservatorship. So now I want to ask for stuff as it relates to outside of the conservatorship. I want to see those text messages and emails too. 16, all correspondence relating to Britney Spears' current or past medications. All correspondence related to Britney Spears' hospitalizations. All correspondence relating to Britney's stays at non-hospital residential medical facilities, including rehabilitation facilities, and that would include Bridges to Recovery. That is going to also be the same exact place that Sam Ingham told Britney she wasn't even allowed to talk about what happened, because if she talked about it, the place might sue her. So I'm always wondering whether or not Lou Taylor had a financial interest in any of these recovery and rehab houses. And I feel like she does, but that's just speculation. Let's see, where were we? Okay, number 19, all documents reflecting the time that the TriStar people have spent working on behalf of the conservatorship estate of Brittany for each year from the exception of their retention, which would be like 2008 at least, because I have documents in this folder right here that show that Lou Taylor was working with conservators as early as June or July 2008. So it would go back at least that far. Even though Lou lied and said she didn't start working with the conservatorship until 2009, she lies all the time. She's a liar. So if you think that's not true, Lou, please sue me and we will go to court and I will show you all the different times you have lied, and then you'll look stupid in front of a judge and jury. We'll do that if you want to, but I'm sick and tired of you. She's literally harassing me. If you're brand new here and you're just like here for court documents, like this woman literally made me leave my first lawyer job and tried to hire the law firm to create a fake conflict of interest. Then when I went to YouTube and started making videos, she tried to get my channel removed. So I have a personal interest in making sure that she serves her time, whatever the case may be, for being such a liar and a despicable, deplorable human, because she has personally targeted me. So run and tell that. Okay, now we're on number 20. All documents that refer, reflect, or relate to any benefits you, that's TriStar, and your representatives, including Lou Taylor. God. I am giddy. I am so sorry. I am giddy. If this is your first time here, hi, welcome. I'm usually not this hype. Okay, so they want to, thank you so much, Helen. Yeah, I am literally going off, y'all. I am hot. I am like, this is like bringing me so much joy. They should never have been able to get away with this. But They were, and they did, and now they're not anymore, and I'm so happy. So number 21, they're saying, or number 20, they're saying, we want all documents that relate to any benefits you got and your representatives, including Lou Taylor, that have received as a result of your representation of the conservatorship estate beyond monetary compensation. So this means that I'm not just talking about money, Robin. What about cars, concert tickets, meet and greets? I definitely saw you meeting Bill and Hillary Clinton. Was that one of those perks? Thank you so much, Aisling Bonnie. Yep, no, and I agree, Diana. I'm going to talk about it. No, people giving me a hard time are all on Lou Taylor's payroll. Like at this point, I'm convinced, and that's just speculation. A lot of these alleged fans like siding with Lou all of a sudden, and it's really weird to see these alleged fans doing that. Like, you're not a fan of Britney if you're siding with Lou Taylor. Like, think about it. Just think about it. Ask yourself who would be doing that. Okay. Especially these alleged fans that, took $20,000 in settlement money from her. Like, sorry, you're not a credible source, honey. Okay, 21. All documents that refer, reflect, or relate to the monetary compensation that Robin had as a result of her representation of the conservatorship estate of Britney. Number 22, all organizational and corporate formation documents for all entities created for the benefit or purported benefit of Britney Jean Spears. All organizational and corporate formation documents for all entities that have received or held conservatorship estate assets. That is Stonebridge. That is Stonebridge Investment Counsel. The investment firm that Lou Taylor worked at and founded and then wanted me to stop talking about, and then came to my employer to try to bully me, harass me, and scare me into not talking about. That's Stonebridge Investment Counsel, also known as Stonebridge Wealth Management, Louise. That's exactly what Matt Rosengart is asking for. Give me Stonebridge's books and records. Give me their their organizational documents, and let me really see who it really is that's the owner of those companies. I feel so vindicated, y'all. Like, the way that my employer treated me, like I was the dumbest, stupidest idiot in the whole world for making some of these allegations. And I was right. I was right. I'm about to cry. Okay. Oh my God, I'm so excited. Okay. All organizational documents, you and your offices. Okay, so that's the end of that page. Let's go to the next one. All correspondence relating to Britney Spears' current or past medications. Oh, we already read this one, right? We already read that. Okay. All correspondence other than privileged. Thank you so much, Frank. Other than privileged communications relating to whether Britney wanted or did not wish to work a second residency in Las Vegas. So he's asking for all of the communications and documents and the messages and emails and things having to do, thank you so much, Kristen, having to do with whether Britney actually wanted to work that Vegas residency or not, because she told the court on June 23rd, 2021, that she did not want to work that Vegas residency, and she was approached by management with a contract and forced to sign it, and they said, if you don't sign it, we can sue you. And so that's kind of like what is going on with that request. I'm sorry, I'm allergic to this microphone cover and it makes my nose itch. Okay. And then number 25, all correspondence other than privileged communications with the attorneys relating to whether Britney wanted to work again for so long as Jamie was her conservator. The last one is correspondence relating to security, and he put that in quotes, or monitoring efforts, that's more like it, of conservatee Britney Jean Spears or of her associates, fans, or persons of interest by Black Box Security or any other security firms or individuals, including but not limited to surveillance, monitoring, cloning, iCloud mirroring, or recording of calls, emails, text messages, internet browser user history, and social media use or direct messages on social media. Yes, yes, yes. Thank you, Claire. Okay. So we got those. Let's go to these. Now we are on to, now we're on Exhibit B continued. Produce the persons most knowledgeable qualified for TriStar Sports and Entertainment to testify. Thank you so much, Nasib, regarding the following categories. Okay, so they're saying, look, we don't really even know who to ask these questions to, but these are the questions we have. So y'all need to send us the appropriate party to come answer them. Y'all's comments are so nice. So the person most knowledgeable for the following categories. Category 1, surveillance of Britney Jean Spears, including electronic surveillance, monitoring, cloning, recording of the activity of Britney's telephone, but not limited to the surveillance, monitoring, cloning, iCloud mirroring of recording calls, emails, text messages, internet browser use or history, and social media use or direct messages on social media. Recording or listening devices placed in the home or bedroom of Britney Jean Spears, including the involvement of Robin Greenhill or TriStar in the decision to place any such recording or listening devices and the records of any such recordings. Yes, 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 yes. Yes. Number 3, services purportedly provided by TriStar Sports and Entertainment to Britney Spears, the conservatorship of Britney Spears, and any entities affiliated with Britney from 2007 to present, including but not limited to business management, accounting, and tour accounting. Thank you so much, Heather Higgs. Riley said I had to send you money since she made $10 yesterday. Aw, Riley. Y'all are so sweet. Take your $10 back. That's so sweet. Thank you, Riley and Heather. Okay. And then number 6, any agreements and modification of agreements with James Spears, Britney Spears, and the conservatorship of Britney Spears or Black Box Security. Yes. Discussions involving TriStar relating to the finances of Britney Spears. I think most of these questions are going to be answered by either Lou Taylor, Jamie Spears, or Idan Yemeni from Black Box Security. And then we have number 9, all corporations, companies, or any other entities created or set up by TriStar, any representative of TriStar from which James Spears received any compensation. Y'all, we are just getting started. Exhibit C, deposition subpoena for personal appearance and production of documents and things from Robin Greenhill. So this is going to be like all the same stuff I think we already read. Eavesdropping. Yeah, we read this stuff. Relate to... I don't want to read all the same things twice. I'm just going to skip it if it's not. Some of these are the same. Some of them are slightly different. This was to Robin Greenhill. Any compensation or modification to the compensation agreement between Robin and the conservator. So that's like, did Robin get paid directly from the conservatorship, basically? All documents, right, relating to payments or approvals for payments made out of the conservatorship estate of Britney Spears for legal representation of Lou Taylor or Robin Greenhill. That would include suing alleged fans. The accounting services. So same questions again. I think these questions got asked to Robin and to TriStar. Okay, so let's get to the next one. D. Okay, now let's get into... I am so excited. Okay, so now we're looking at an October... Well, let's see what noted your honor said. Exhibit D, a letter from Edelman to Rosengart. So this is a letter that is from Robin Greenhill and TriStar's lawyer to Matthew Rosengart. And the title of the letter, the subject line is Request to Meet. Thank you so much, Esme. Thank you for standing up to that monster. Yes, hashtag Free Britney. Thank you. I am writing. This is a letter to Matt Rosengart. So this is the new lawyer, right? Gibson Dunn. I actually have a friend there too. Y'all, the firm I worked at was like the same type of firm as all this. I am so glad I got out when I did, because it's like I have friends from my law school class who are working at this law firm right now. Like now they're representing like conservators and crappy lawyers and criminals, perhaps, allegedly. So here's the new lawyer. Dear Matt, I am writing to follow up on our phone conversation on October 12th. So this was October 18th, just like 3 weeks ago. During that call, you raised the subject of my clients challenging your October deposition subpoenas and told me that if my clients decide to exercise their legal right to object or challenge what they view as vastly overbroad and burdensome subpoenas, you would publicly unload on TriStar in a no-holds-barred manner. So basically what they're saying is, we were at a meeting on October 12th. And they're talking to Matt Rosengart, right? They're talking to Brittany's lawyer, and they're like, and you said if my clients exercise their legal right to object to your subpoenas that you would unload on TriStar in a no-holds-barred manner. And that he sure did. He told the truth. He told y'all the truth. Okay. Oh my God, there's okay, hold on. Wait, pause really, really quick. This is an important announcement. If you're in the area tomorrow in LA, please join. They are going to be protesting TriStar in front of the building at 1 p.m. California time. Sorry, using voice chat. Thank you, pretty little writer girl. Okay. Oh my God. Yeah, y'all got 809 people and only 13 likes. That doesn't seem right. That seems like a lot of haters are in here or something. No, because it would have more down likes. Dislike it if you want to too. That's also engagement and gets this message out further. Okay, back to this letter. You told me, so this is Robin Greenhill's lawyer talking to Matt Rosengart on October 18th. You told me that, quote, you were not threatening me or my client, but that I needed to understand the potential consequences of challenging your subpoenas. I told you that you were in fact threatening me and my clients and that it was irresponsible for you to do so. I told you that my clients have not done what you have alleged. More fundamentally, I reminded you that as you try your case in the press, every allegation you make further provokes countless bleep threats to my clients. Not true. I've never seen a single bleep threat. Their staff and families. Okay, well, boo-hoo. What do you think Brittany had to go through? Way more than a threat. She actually went through real abuse at the hands of your client. So why are you coming in here acting like they the angels that need to be protected here? That's disgusting. And this is the type of thing that I would have been dragged into doing if I kept working at Winston & Strawn LLP. I would have been representing these monsters and had to sit there and act like I was doing it in good faith. Like, what do you think this Edelman guy thinks about Scott Edelman when he sits down at night? Like, you know he don't feel good representing these monsters. Let's see, blah, 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 threat. And the clients of the firm, as well as the church where Miss Taylor's husband is a pastor. That church is called Calvary Chapel, Brentwood. And actually, I believe Lou Taylor is a founder of the church. It's not just some church where her husband is a pastor, sweetheart. They own the church. And they also just bought $1.3 million home and they're calling it a church. So it's not because of unwarranted allegations. It's because of what they've actually done. This guy says, you would be knowingly putting my clients at serious risk of physical harm by seeking cover under the litigation privilege to try your unfounded case against the court of public opinion. Whoa. We're sad because Lou Taylor isn't in charge of the media narrative. That's basically what this letter says, just so, to put it in regular terms. Over 2 months ago, this guy sent Matt Rosengart a 32-page document that contained just some, although certainly not all, of the death threats my clients have received. Well, get some security. Y'all are friends with Black Box. I have reattached that document to this letter. Lou and Robin continue to receive death threats. These millionaires can't afford security. Boo-hoo. Wah. And I have had to deploy security to protect them and other TriStar employees. Well, good. That's what security's for. I cannot understand. Also, I do want to say right here, nobody send death threats. I don't believe it's real. That's why I'm downplaying it. But y'all don't make it real by doing it, okay? I feel like I have to put that disclaimer here. I cannot understand how you think it is appropriate to use your position as Miss Spears' counsel to threaten my clients. Oh my God. How many times has Lou Taylor used her position as Britney Spears' manager to do all kinds of threats? How many times has Lou Taylor used her position to threaten people? It's happened to me twice. Twice she's threatened me. She's threatened my law job and she's threatened my YouTube channel. She's used her position to threaten people, but y'all don't like it when other people use their position to do the same thing? How'd that work? I can understand how you think it's appropriate. Well, this is part of the litigation process. If you don't understand that, Edelman, you need to go back to law school because I understand and I've been a lawyer for about 15 minutes. When you know full well that the safety of TriStar's employees and others are at stake. When I asked you directly whether you had leaked to news outlets your issuance of subpoenas, given the multiple press accounts of the subpoenas, you told me no. And advised me not to believe everything reported in the media. I now ask that you extend my clients the same courtesy. My clients dutifully served Miss Spears for nearly 13 years. Yeah, that's the wrong verb. I think you mean trafficked. They have always cared and still care for her welfare. I don't believe you. You're lying. As I attempted to discuss with you on prior occasions, no one at TriStar suggested that a conservatorship should be established over Miss Spears. Well, that is not what Lynn Spears said, and that is not what Britney Spears herself said. She said that Lou Taylor was the mastermind, basically, now in a now deleted Instagram post. No one at TriStar has had any control regarding Miss Spears' medical treatment. Lies. No one at TriStar has ever suggested monitoring Miss Spears' electronic communications. Lies. And no one at TriStar is aware of any electronic surveillance device placed in Miss Spears' bedroom. Lies. Though you have refused my offers to make my clients and documents available to you informally to try to assuage any concerns you might have related to the 12th accounting, we will cooperate with you and gather documents relating to Miss Spears' Brittany's objections to the open 12th accounting, for which discovery is proper at this juncture. So basically he said, well, we tried to get off the record with you. We didn't want to do a deposition, and you weren't cooperative. Like, depositions happen in court cases. It's just part of it. Like, that's part of the thing. However, we will not produce documents as to any prior accounting that has been approved by the court, not to mention by Brittany and through her court-appointed guardian ad litem, and is therefore final. We intend to produce Robin Greenhill in both her professional capacity and as a TriStar representative, potentially along with others, to testify about issues related to the 12th accounting. But we need, and again, that issues related to the 12th accounting includes Lou Taylor settling a lawsuit with an alleged fan in the hundreds of thousands of dollars in legal fees. She tried to charge Britney Spears' estate hundreds of thousands of dollars to sue an alleged fan for making a website about her. Hundreds of thousands. That's just one issue on that 12th accounting out of millions of dollars of issues, right? I know, Angela. I agree completely. Okay. So they're saying no. Things were already produced and approved by Sam Ingham, so for that reason, you're not allowed to look at it, which is complete and utter baloney, because Brittany did not have a meaningful opportunity to examine those. Sam Ingham was never doing his job. He didn't know what he was looking at. We need to see every single thing, and y'all are going to have to produce it. So this little waste of money doing this thing right here, trying to fight it, is just a waste of your time, Edelman. We intend to produce, okay, let's see. TriStar can begin. We need additional time to do so. Beyond the unilateral October 28th and 29th deposition dates listed in the subpoenas, TriStar can begin producing relevant material on a rolling basis starting no later than October 29th. And we can discuss a time frame to complete the rolling production and schedule the deposition after the production is complete. The subpoenas also seek to depose TriStar and collect documents concerning a number of other issues. Example given: the establishment of the conservatorship, communications regarding financial and medical issues unrelated to the period covered by the 12th accounting, and alleged electronic monitoring and surveillance of Brittany that have nothing to do with the 12th accounting and bear no relationship to any pending or contested petitions in these proceedings. As a result, we do not believe those issues are proper subject of discovery at this time. And then they cite a case, and the case stands for the proposition that generalized document demands, insupportable by evidence, showing at least the potential evidentiary value of the information. Okay, so basically there's a disagreement between Matthew Rosengart and TriStar's lawyers on whether or not Matt is actually allowed to ask for all this stuff. Robin and them, TriStar's side, is saying, he doesn't actually even have the legal right to ask for it. And Matthew Rosengart is saying, oh, yes, I do. And because I'm biased, I'm going to go with believing Matt, but that's really the only reason. Okay. Please let me know if there's a convenient time early this week to meet and confer to discuss my client's proposal to limit the subpoenas to issues concerning the open 12th accounting, and 2, to produce documents relevant to that accounting on a rolling basis, and 3, to postpone the deposition until date and time mutually agree. So they're trying to get out of depositions, and this is exactly what happened in the lawsuit with that alleged fan. It was like the day before, some like day right around whenever Lou Taylor was supposed to go to deposition. She didn't show up for it, and it was a big deal about the deposition, and that's why she ended up settling for $20,000. I'm available the following times. Okay, so that was Exhibit D. Now, this is going to be fun. Let me see what my bestie said. So noted, Your Honor says, this is Exhibit E. This is Rosengart flaming Edelman via email. Okay, I cannot wait. I cannot wait. He has this sans serif font. I'm so into it. I'm so excited. Let's go. He sent it on October 18th, the same day of his letter, and he just sent it right at 1:40 p.m. So he wasn't wasting any time. He just sent it right on back to Edelman. He says, Rosengart said, to be blunt, your letter this morning is outrageous and disgraceful, both factually and as a matter of law. And candidly, you should apologize. Many of the statements in your letter, which are knowingly false or gross mischaracterizations, are simply beneath you and they are rejected. Unfortunately, your statements are now a part of a pattern from your side, presumably so that you can seek to make a false record for your client or try to intimidate me or my firm. Your statements, misleading characterizations, and implicit threats are highly inappropriate. You or your client might not care about the truth and are apparently trying to cover it up, but I am duty bound to continue to obtain it, despite your side's ongoing efforts to delay and obfuscation. You are certainly entitled to be an advocate for your client, but you are not entitled to fabricate things in order to fit your narrative. A point-by-point rebuttal of your letter is beyond the scope of this email, and I will be responding by separate letters shortly. But for present purposes, I am compelled to correct a few of your letter's most glaring false statements and mischaracterizations. You lying... I'm just kidding. He didn't say that part, but I feel like he said that part. You know what I mean? Like he was mad when he wrote this. First. Whatever legal or other problems your client has are obviously not of my making. So your little death threat things and all that crap, that don't have nothing to do with me. That have nothing to do with Matt Rosengart. That's not my problem. I don't know what that has to do with anything about the truth, because I'm here for the truth. So all your little about wham putting people in danger, that is bull. That is false. And I'm not going to sit here and take it. And I'm going to put it in the filing so that everybody on the internet can read it, including ThatSurpriseWitness, to like 1,000 people. First, whatever legal or other problems your client has are obviously not of my making. What a sentence. Your claim that threats your client is supposedly receiving because of me is not only obviously false, it is shameful, as is your odd and irrelevant reference to religion. Yeah, what does that have to do with anything? Why are you putting religion in here, you weird freak? As I have explained to you before, and as you must know, I have been extremely restrained and tepid in any comments about your clients. And moreover, your claim that I'm trying my case in the press is demonstrably false. Indeed, if you did your homework before sending your letter this morning, you would have learned that I did not even mention your clients on September 29th, before, during, or after court. If anything, you should be thanking me, although I am obviously not looking for that. Instead, you're engaging in a baseless attack, presumably for your client relations or because you think it will give you some tactical advantage. Your side's intimidation and other tactics are ill-advised and should stop. Second, while long on rhetoric, your letter completely ignores that I repeatedly sought your cooperation. You brazenly and emphatically rejected my efforts. Specifically, and among other things, my email dated September 15th, I asked you for 2 basic pieces of information. 1, a copy of TriStar's business management agreement with my client, or the estate, if any, and 2, the revenues received by TriStar. 2 basic pieces of information. You initially failed to even respond to my email, let alone provide this fundamental information. I patiently waited for you. And when I followed up with you, after not receiving any response, you sent me an evasive, non-responsive email, and then later stated that you would not be providing the information. Your position that this fundamental information is somehow not relevant is baseless and insulting. Your client acted as my client's business manager. My client is entitled to the requested information, and your client has a fiduciary duty to produce it. I cannot understand how you think it is appropriate to withhold this basic information, which, even putting aside relevance of discovery, your client has a legal obligation to provide. She has to give this stuff to us. What are you sitting around here playing with me for, Edelman? Is basically like the translation. Further, although it is not necessary for me to prove relevance to you in this email, given the very liberal standards for discovery, this and other information requested is directly relevant to the issues of removal of James Spears, termination, and your client's fiduciary obligations. Moreover, if your client had nothing to hide, you would simply produce this information. if your client had nothing to hide, you simply would produce this information. Instead, you have chosen delay, obfuscation, without legal support, and indeed in violation of basic legal principles. Come for his license, Matt. You are certainly welcome to send me all the documents regarding the 12th accounting. For all the reasons herein and in my previous email to you, and this case law I already cited and told you, precedent, our investigation is not limited to the 12th accounting, nor could it be. And again, regardless, the notion that you can for some reason withhold the management agreement and revenue totals is legally insupportable as a matter of discovery, as well as a violation of your client's fiduciary legal duty. Finally, in addition to rejecting your false characterization of a threat, I must add that your reference to saving attorney's fees is rather rich, considering the many millions of dollars obtained by your client from my client's estate, and two, your client's billing my client's estate for substantial monies for services rendered to your client. That means Lou Taylor billing Brittany's estate for legal lawsuits. Lou Taylor billing Brittany's estate, that's really rich. It's really hilarious that you're talking now about attorney's fees and saving money. It's really cute, Scott Edelman. It's really precious and adorable that you're worried right now about attorney fees whenever your dumb client, this is like the translation, right? Whenever your dumb client already charged my client's estate money for a lawsuit that didn't have nothing to do with my client. So now you worrying about fees? All right, so oh wait, hold on. As I have advised you before, how many times have we said this sentence, Free Britney Movement? How many times have we said this sentence? The truth is on our side. The truth is on our side, and we will continue our investigation. I will write separately in response to the rest of your letter and let you know of my availability to meet and confer further this week. Thanks for your email. Okay, so who is this to? To Scott. Okay, so this is like an older email here. Okay, so this is the previous email. So the one we just read would have come after the one we're about to read right now. Here's the October 1st email. This is Matt Rosengart going in on this lawyer even more, but this would have been at a previous date. It is wrong and false in many letters. Hold on, let me see if I can find his. Let's see. No, I can't. Okay. That's fine. It's just going to be more like Matt Rosengart flaming this guy. Okay. Unfortunately, it's wrong and false on many levels. You know better, but clearly you wrote this for your client. Not that it matters or excuses your tone. Bloop. Saying I will not return your calls is false, and you know it, and is more than disappointing for you to write that. We have spoken multiple times, as you obviously know, and there is an email trail showing your lack of availability due to your deposition and mediation schedule. I acknowledge we both have been busy, and I'm not necessarily blaming you, but your characterization is wrong and belied by the written record. And I even agreed to meet with you at your request on a weekend. You claim you wanted to be cooperative, and yet when I asked you for the most basic of documents in my September email, a business management agreement, if one even exists, which evidently it does not, you initially ignored my email completely. Then, after I patiently waited for a response, any response at all, I followed up. And you sent an evasive, non-responsive email. Now, it is more than 2 weeks later. You still won't produce a management agreement between TriStar and Britney Spears. In fact, you've not confirmed that you will not, nor will you confirm how much your client has been paid, aka taken, from Britney Spears or her estate. The relevance of this information is obvious, as you know, not only for TriStar, but for Jamie Spears in regard to his fiduciary duty issues, who was suspended earlier this week. I've asked you for basic information multiple times. Your failure to respond makes it clear that your client's professed cooperation was not in good faith. So be it. As for what I have said about TriStar, you should actually thank me for being as restrained as I have been, particularly in view of recent disclosures and highly credible allegations by a whistleblower concerning TriStar and Robin Greenhill in particular. Finally, like much of your email, your statement that there was a false... Oh, it's gone. Okay. So I don't know the rest of that. So let's go to Exhibit F. Rosengart flaming Edelman again via letter, Let's do it, baby. He knows the law. Okay. More Rosengart going in on Scott Edelman. More the next day. Dear Scott, this is in response to your letter dated yesterday, which, to be blunt, was in many respects appalling. As you know, your letter is replete with false statements and claims, and it is also wrong on the law. Ooh. So you lied and you don't know the law. That's pretty bad for a lawyer, Scott. Many of the statements in your letter, which are knowingly false or gross mischaracterizations, are simply beneath you. But disappointingly, they are now part of a pattern, presumably so that you can seek to make a false record for your client to try and intimidate me or my firm. Your statement's misleading. Oh, wait. We read this. Oh, we already read this just now. This is just the letter version of the thing we just read. We didn't see this part, though. As I have advised you before, the truth is on our side, and we will continue our investigation despite the tactics we have seen from your side. Finally, yeah, I just want to make sure we had read that stuff. Okay, finally, although ample notice was provided, including to the conservator of the estate, which would have been Jamie at the time, while expressly reserving all rights, I'm willing to extend the courtesy of rescheduling the depositions, but we will need to set the dates for them and the document productions to occur in the near future. We can set a time to discuss. Okay. Exhibit G, more cockfights via email and correspondence. Here's Matthew Rosengart. Again, this is the same day, this is October 21st, so 2 days later. Scott, Monday does not work for me. Tuesday I'm available. Please let me know if those slots work. With regard to the two basic requests I have made, you have still failed to provide direct answers. First, if there were a business management agreement, TriStar would have it. It has now been well over a month since my September 15th email to you, and you have still failed to produce any such document, and based upon the below, it is evident that it does not exist. Second, I do not understand the basis for the continued obfuscation concerning the total revenues taken by TriStar from Britney Spears and her estate. We were all aware of the unredacted filings, and I don't understand why your email address is only 2020 and 2021. Again, please provide the total revenues. Okay. I want to make sure. Let's see. This is 5:29 p.m. So let's go like backwards. Hold on. 20th. Okay. So we'll start here. This is an email from Scott on October 20th to Matt Rosengart. Matt, unfortunately, the time slots do not work. If anything opens up Thursday morning for you, please let me know. Otherwise, we can meet and confirm Monday morning between 10 and 11. Our motion to quash for protective orders is otherwise due this Friday. Would you be willing to give us an extension? And then Matt goes, Scott, I'm fine with your requested extension, assuming it's reciprocal regarding my enforcement of the subpoena to TriStar if necessary. Also, on behalf of my client, Britney Spears, I once again request 2 pieces of information. And he asks again, I need the management agreement, and I need how much money Lou Taylor and TriStar have been paid from 2008 to now. Even putting aside litigation issues in the subpoena, my client is entitled to this information. She's entitled to the information of the agreement she's a party to. Your client has a fiduciary duty to provide it. There is no reasonable basis to withhold this information. Thank you. And then here comes Scott. Matt, we agree that moving the subpoena response deadlines to November 4th and 5th would move the deadline. Okay. So they agreed to that logistical thing. As for any motion that Britney may want to file in connection with the subpoenas, that will be keyed off the new subpoena response deadlines are the 10 a.m. Okay, this is just logistical stuff. Separately, you keep asking us for fee information and asserting that it's somehow improper that we have not given it to you. We don't understand the basis for your request or the basis for your assertions of impropriety because you have the unredacted filings reflecting every dollar paid to TriStar and approved by the court. As for fees in 2020, TriStar was paid $266,796. In 2021, they were paid $154,000, which was supposed to be paid in 2020 and covered the work performed 2020 at a prorated amount of $500,000 per year where TriStar serviced the estate for 10 months through October 2020. As for the business management agreements, you already have the May 2009 business management agreement that relates to TriStar's work on the 2009 circus tour. On October 24th, 2009, the estate's then entertainment counsel, Goldrick, Hertz, and Lichtenstein, sent co-conservator Andrew Wallet an email requesting his signature on the final business management agreement, which have been signed by Jamie and TriStar. We understand from Mr. Wallet that he signed this agreement, but neither Wallet nor TriStar have been able to locate a version of this agreement with his signature, given it was likely maintained in paper form and may not have been retained. But this is not, there has been somebody who worked at Andrew Wallet's law firm, Katerina Perot, who has come out and said, I worked at his law firm during this time and we kept everything on computer records. So the notion that somehow this would have been a paper agreement that wasn't stored electronically is disputed by someone who actually worked at Andrew Wallet's law firm. Secondly, it's pretty weird that they have emails with an attachment of a document here, but they didn't have emails receiving the document. Does that make sense? Like, did he put the paper agreement in the mail and mail it and y'all lost it in the mail? Like, that does not seem like likely in 2009, especially a hundreds of thousands of dollar agreement. It definitely seems like something they would have kept and held on to unless they have some reason to be hiding it. We have not been able to locate a signed written agreement to TriStar's business management services for the estate generally, but a draft of the business management agreement intended to cover that work was sent to the co-conservators and their counsel on December 2nd, 2009, and contains substantially the same provisions as the circus tour agreement. The parties' performance, acceptance of benefits, and course of conduct over TriStar's 11-year tenure as the estate's business manager reflect the parties' intent to be bound by that agreement, blah, blah, blah. In any event, the terms of the May 2009 agreement expressly apply to any additional services requested by the estate. So again, I mean, we haven't seen this document that they're referring to, so I'm not really sure what the deal is with that. And then we've already read this one right here, right? Again, provide the total revenues from the estate, the inception, and all that. Okay. More bickering via letter. This is now on October 25th. Now, this is from Matt to Scott. And the subject line is TriStar's ongoing failure. Hold on, let me let my cat in. Sorry, y'all. She just like meows until I let her in. Okay. Sorry. Oops. What are we doing? This is the one I want. Okay. Okay, here's Matt Rosengart on October 25th. Dear Scott, as you know, on September 15th, I made 2 requests for basic information from your client TriStar. First, I asked for a copy of any business management agreement between TriStar and Brittany or the estate. Second, I asked for the total revenues paid to or taken by your client TriStar from Britney Spears and or the estate from inception. You initially failed to respond to my email at all. Accordingly, I renewed my request on September 21st. It has now been well over a month, and our very simple, very reasonable requests have been met with non-responses and evasive answers. On the first point, it is evident there is no signed management agreement. On the second point, revenues to TriStar since inception, there is no basis for your continued stonewalling. Indeed, while you have professed cooperation, your and TriStar's non-responses speak volumes. This information is obviously directly relevant to the proceedings in the probate court, including the November 12th hearings regarding the termination and removal of Jamie. It concerns, among other things, whether he breached his fiduciary duties. It is also directly relevant to the financial and accounting issues to be heard on December 8th, which concern Mr. Spears, TriStar, and others. Oh man, I might be going back to California, y'all. I gotta be in this accounting hearing. I need to book my flight today. However, even pushing aside the above and also putting aside the outstanding subpoenas served on TriStar and Robin Greenhill, as a business manager, TriStar obviously owed and owes a fiduciary duty to our client. And if your client TriStar had nothing to hide, as you claim, it would simply produce the information as any reputable business manager would have done a long time ago. We obviously have the accountings, but we have reasonably asked for this information directly from your client. Your failure to respond begs the obvious question: what is TriStar hiding? We are not interested in a further back and forth, let alone further evasion or stonewalling, and hence ask one final time. Please produce by 2 p.m. tomorrow the total revenues received or taken by TriStar from Britney Spears or the estate. Thank you very much. Sincerely, Greenberg Trarg, Matthew Rosengart. Okay. Thank you. Okay, this is apparently a very lengthy letter. I actually have to get on a plane soon, so we might have to do a part 2. Okay, Exhibit K, a very lengthy letter where Rosengart lays out the law and points out malfeasance on behalf of TriStar, including a mention in footnote 2 that Lou herself charged the estate for an advertisement of herself in the Hollywood Reporter. Oh my God, okay. I'm definitely reading this letter, and then I gotta go. Okay. I am so excited. This was sent November 2nd, so a week ago. Oh my God. This is the subject line. TriStar and Robin Greenhill's failure to comply with subpoenas, failure to produce financial information to Britney Spears, failure to produce emails and text messages regarding placing listening devices in the bedroom of Britney Spears, iCloud mirroring of phones used by Britney Spears, and revenues received or taken from Britney and or the estate of Britney Spears. Dear Scott, we write in response to the above referenced matters, as well as your letter dated October 29, 2021. As an initial matter, your more than 6-week delay and your Robin and TriStar's blatant refusal to provide our client Britney Spears with basic financial and other information is both troubling and completely unacceptable. Specifically in response to your professed claim of cooperation by emails and letters dated and running through late October, I request 2 basic things. And again, he repeats his 2 things again. For more than 6 weeks, you and or your clients have stonewalled and obfuscated. You have blatantly failed and refused to provide this basic information. Your defense is that TriStar has no fiduciary duty to provide this information, and begging the question, you resort to your mantra that the information is in the accountings. TriStar's stonewalling and obfuscation is not only unacceptable, it's legally untenable. It is undisputed. It's not disputed. There's no fight. There's no disagreement. TriStar was the business manager. And TriStar for many years publicly touted its business management relationship with Britney Spears and built its business based off Britney Spears. There it is. There it is. For many years, TriStar went on out in public and told everybody, oh, it's Britney Spears is our client. Oh, Britney Spears estate. Britney Spears this, that. Matt said they built their business on Britney Spears and the substantial revenues produced by Britney, literally hundreds of millions of dollars through Britney Spears' hard and extraordinary work. Look at 2. As the 12th account shows, TriStar even charged a conservatorship for an advertisement for Lou Taylor in the Hollywood Reporter. Even putting aside TriStar's fundamental legal duty to provide my client with this basic financial information, and even if you stand by your meritless position that your client doesn't have any duty to provide it, any reputable CPA or business manager would simply and willingly provide this information. And it would have done so a long time ago, immediately. This is particularly true given the bullying and abuse that my client has had to endure. He's saying Britney has had to endure bullying and abuse. Instead, TriStar is continuing the pattern of bullying, asserting flimsy, legally unsupportable excuses for its continued stonewalling. Yep, I've been a victim of TriStar's bullying whenever they tried to get me silenced by my employer. How'd that work out for you, Lou? How you feeling about that decision? That wasn't a real smart one, was it? Accordingly, and so the record is clear, despite TriStar's reaping of millions of dollars from Britney Spears' hard work, much of which TriStar and Robin Greenhill imposed on her. There's that trafficking. There it is. So if they didn't force Britney to do this work, they wouldn't have got these millions of dollars. So that's literally the definition of trafficking. It is literally human trafficking to force someone to work so that you can make money off of them. It is. When you impose work on someone and it's not their free will to work. It is evident that TriStar never even had a governing written management agreement. With regard to the financial issue, we make the request one more time. Okay, Matt, stop doing it one more time because you already did it one more time and you're losing your thunder when you do that. You know what I mean? Please provide the total fees taken by TriStar from Britney Spears and or the estate of Britney Spears from 2008 to present. Notwithstanding TriStar's moral and legal obligation to provide this simple information, TriStar's ongoing failure to answer this question speaks volumes and leads to the unfortunate and inexorable conclusion that TriStar has much to hide. If the moral imperatives are not enough, including the millions TriStar reaped from Britney and her estate, Responding to this basic information is mandated under California law, given that TriStar had a fiduciary relationship with Britney Spears and her estate. Indeed, for well over a decade, TriStar exerted domination and control over Britney Spears and her estate. For well over a decade, TriStar exerted domination and control. Is this a hint? Was it called domination because they were letting Britney know that she was being dominated? Is this a hint, Matthew? Scratch your nose at the next press conference if it was a hint. I'm saying that because my nose is so itchy. I'm allergic to this foam. Specifically, TriStar was improperly, heavily involved in many aspects of the conservatorship from its very outset, including medical decisions, medical expenses, and claim processing. TriStar also controlled financial decisions, investment decisions, paying bills, accounting services, money management, estate planning, tax planning, while also serving as the tax preparer and CPA. Finally, we know who is the CPA. We all assumed it was Lou, but this is a good confirmation. So what is footnote 3? Indeed, TriStar openly affirms that it provides accounting and financial services aimed at protecting its clients' well-being. That include paying monthly bills, cash management, trust, wills, estate planning, real estate acquisition, sales, rental, medical processing, and the like. See your own damn website. All of these facts and many others overwhelmingly demonstrate that TriStar had a fiduciary duty, a proposition which, as a matter of law, is axiomatic. Okay, so that's basically just saying, like, TriStar has a legal obligation. Like, they're literally obligated by law to give me these stuff. So I don't know why you keep acting like you're not. We're not going to read through all this stuff. This is just case law, case law, case law, case law, case law. Y'all can read that if you want to pause and read it. Further, as you likely know, the duty of a fiduciary embraces the obligation to render a full and fair disclosure to the beneficiary of all facts which materially affect his rights and interests. And this is from Neal versus Magna. So this is saying, like, you are required. You did, like, here's a wall of case law telling you got to do this. Oh, look, that's not good enough for you. Here's a footnote. Since the subpoenas seek documents related to matters that materially affect Britney's rights, including but not limited to her financial affairs, the apparent dissipation of funds from her estate. Do y'all remember whenever we were like, free Britney now? And people were saying, oh, it'll never end. It'll never end. It'll never end. Well, I think this is why they thought it would never end. Because they have so much to hide that if it ever ended, just people would just go to prison. I feel like. Invasion of her privacy by, among other things, monitoring her phone and text messages, including her attorney-client communications, contemporaneously in real time. I wonder if they looked in on her and Rosengart's communications. And placing a listening device under her bed or in her bedroom. TriStar's fiduciary obligations independently require prompt disclosure. I was reading the footnote. None of these situations is relevant or even analogous to TriStar's role as Britney's business manager, among other things, to control the responsibility for finance. Okay. As you are undoubtedly aware, fiduciary relationships also give rise to the remedy of disgorgement, which explains but does not excuse TriStar's claim that it was supposedly somehow not a fiduciary. Okay, so this is just a little bit more in the weed stuff. This should put to rest your and TriStar's meritless claim that TriStar had no fiduciary duty to help Britney and her, This should put to rest you and TriStar's meritless claim that TriStar had no fiduciary duty to Britney Spears and or her estate. But again, even if you maintain that meritless position, and even if you continue to refuse to comply with the subpoenas, if TriStar had nothing to hide, it would simply respond to the above referenced question and provide the total revenues it took or received from Britney Spears and or her estate. Because there would be nothing to conceal, and your clients would proudly and professionally turn over the evidence. But they are not doing that. Next, it is, of course, not just fiduciaries who have discovery obligations in California, and your letter is devoid of any legitimate legal basis to resist the requested discovery, even regardless of your client TriStar's obvious fiduciary status. As the Court of Appeal has explained, discovery is broad. Okay, so they're basically just saying, like, you have to turn it over. If forced to move and compel, our only duty will be to explain the relevance of the documents. So they're saying, look, if we have to go to court on this, the only thing we're going to have to do is tell the judge that it's relevant. And it is. So, yeah. As we previously explained, the documents are directly relevant. Now they're arguing about relevance. The documents at issue are also relevant. So they're saying like everything we're asking for is relevant. We don't even have to prove relevance right now. But if we do have to prove it, this is how we're going to prove it, right? And then they say it. In light of the ample record regarding the invasion of Brittany's privacy, and because these issues relate directly to the removal of Jamie, Brittany is entitled to investigate these issues. It's her money. She wants to know how much was spent. She don't have it. She wants to know. Invading Brittany's privacy and concealing from her that her most intimate moments were being monitored and recorded without her consent, or paying someone else to do so, is neither loyal nor in the highest good faith to Brittany. Accordingly, the documents relating to the electronic surveillance of Britney Spears, including capturing attorney-client communications and placing a listening device under her bed or in her bedroom, are relevant to whether Jamie or TriStar breached his duties to Britney or the estate, as well as the above referenced removal, termination, accounting, and financial issues. As previously explained, in addition to the above, these accountings and financial issues involve not only our prior accountings, but pending the future accountings concerning TriStar's coordination or collusion with Jamie Spears to obtain a $500,000 minimum guarantee from Britney or her estate, even after Britney was on hiatus and no longer was performing. They're also relevant in regard to the pending objections on the 12th account filed by Sam Ingham. Payment of personal legal fees paid to TriStar from the estate for litigation undertaken on behalf of Lou Taylor and or TriStar. That's that alleged fan lawsuit. She entered into this lawsuit with this alleged fan, which, I mean, I don't know if this fan is a fan or not. I mean, it doesn't matter. I was not a fan before I was in the Britney Spears movement, but I'm a big fan now. Payments of accounting to TriStar. So again, he's really concerned about that lawsuit and those payments, and so am I. I want to get to the bottom of that. I want to see all the filings from it. I want to read all the filings from it. And guess what? If I ever get my hands on them, I am going to read every line by line, every email. So you better not let me get my hands on it. Okay. Additional payment of $80,000 to TriStar was before the alleged modification of TriStar's agreement, seeking an exorbitant $500,000 guarantee. As an overriding matter, how Britney's money was spent, including whether it has gone to pay for others to violate her rights, is relevant to existing and remaining financial issues as well as accountings not yet approved. This is it. How Britney's money was spent, including whether it had gone to pay for others to violate her rights, is relevant. Duh. Second, TriStar's failure and refusal to provide documents relating to the financial services it provided Britney is equally baseless, and TriStar has failed to provide any basis for its failure to provide these documents, let alone has it met its burden for failures as required by well-established California law. We're unable to do, okay. Documents relating to the scopes. This is just, for example, Britney has objected to the pending accounting on the grounds that payments to TriStar were excessive. Given her existing concerns, she is entitled to explore whether payments to affiliated entities were proper. Third, we are also unable to discern any legitimate basis for TriStar's refusal to produce documents. Okay. Let's see. As part of good faith efforts. So this is just him like laying out his whole court case. So I'm not going to, I sent you a copy of Hudson as a courtesy. In addition to getting the timeline, under a circumstance described herein, let's see. Okay. Under circumstances described in this letter, where there is apparent fraud or misconduct, including concealment, Hudson, this is case law, warrants setting aside accountings. Setting aside means don't take them into consideration. We got to go back into it, right? Like if I think that you might have been fraudulent in your accountings, then I can't rely on your accountings. That's what Matthew is saying right here. Account, okay. Applying Hudson to this case, as the New York Times revealed in late September, phones were being utilized by Britney that were being monitored, and listening devices were placed under her bed in her bedroom, you sick freaks. The 12th account raises other serious issues concerning Britney and TriStar's management of Britney and the estate. Your failure to provide basic information concerning revenues only heightens these concerns. So we're over here wearing y'all are being frauds. And you're making yourself look like frauds. More specifically, by way of a single illustration only, if, for example, Britney Jamie had failed to disclose that he was using Brittany's money to pay black box security, or anyone else to invade Brittany's privacy by placing listening devices under her bed. Failing to disclose that would certainly be material and would constitute concealment and fraud, permitting the court to set aside the approval of the prior accounting. So basically, if the court can find that they did that they paid out of Brittany's money to put a recording device in her room, if her money was used for that, then all these accountings just fall away. And we get to go right back into the beginning and see what y'all did with every penny. These other accountings are not going to hold up. The same is true if TriStar entered into illicit transaction with Jamie or took money from Brittany's estate for fees that should have been absorbed by TriStar and not Britney Spears, as set forth in the November objections. That's the lawsuit with that alleged fan. And TriStar's failure to produce written management agreement governing its activities coupled with the above is also extremely concerning and raises numerous red flags. To the extent that you suggest that Hudson, obtained discovery, you're incorrect. Hudson and no other authorities support your position. In fact, you trying to reference Hudson, but Hudson actually goes on our way, not your way. Rather, as written record shows, I sent it to you for your information as a courtesy well before we served the subpoenas. In short, as noted above, as you know, you're going to have to turn over these documents, was basically like the whole letter. Okay. Then what? Okay. I'm going to have to come back and do these later. Like, I just don't even have... Oh, here's the document. Okay, finally. Okay. So I got to go. I literally have to get on a plane in a short time. So I'm going to have to cut this into a part 1 and do the part 2 later. Thank y'all for hanging out today. Thank you for supporting the channel, supporting me. And I am so happy to see Lou Taylor being given a taste of her own medicine. She has bullied me. She's harassed me. There's no telling what she's done to other people. There's no telling what she's done to Brittany. And so I would really, really like to finish this after I'm in a different state in a different time zone. So I'm so excited y'all were here. Of course, you're welcome. Love you, Zachy. I'll talk to y'all later. This is only going to get better from here. And I can't wait for Brittany to get justice. So I'll talk to y'all later. Facts ain't defamation. Love you, mean it. Make sure you're subscribed. Make sure your notifications are on, because that's the only way you're going to know whenever I'm going live. I do not do these scheduled lives. So as soon as, oh, yay. Lilac Gamer, we'll see you there. As soon as I get a document, I go live. So y'all make sure your notifications are on, especially the next couple weeks, because I'm going to be going live as soon as these documents go up to the extent I can. See some of y'all in LA. I am so excited. I am so looking forward to it. I got my book ready to read on the plane. Facts ain't defamation. Love you, mean it. Okay, bye.